Well, my first proposition is right to get a particular social relationship recognized as a marriage is not a fundamental right, my lords.
Let's read it quickly. Let's read the note.
Yes, but I'll just quickly, my lord, go through. It is submitted that over and above marriage, there are whole host of human relationships which exist in society, which may in some cases be even more valuable than marriage. The statutory law in any country in the world does not regulate all human relationships. The said relationship may be extremely important from the perspective of life and liberty and the dignity attached to it, and may further even have a more profound impact on the life of a person. However, sans a legitimate state interest, legislatures across the world have left a whole host of human relationships completely outside the legislative purview, denying any legal recognition to the same. It is submitted that the presumption, therefore, cannot be that the state is obliged to recognize all human relationships. Rather, the presumption has to be that the state has no business to recognize any personal relationships unless the state has a legitimate state interest in regulating the same. Even for heterosexual couples, it's their intimate relationship state had no business to regulate or recognize. Why the recognition came? Marriages used to take place even prior to 1956 because the court felt that we will have to regulate. You cannot be at free will marry at any stage, any time, at any age. You cannot marry as many times as you want. You cannot just say bye-bye and leave the relationship. You can part with your spouse only on certain grounds. When you are in a relationship, the children might be there. Who will take care of the children? So the question of custody needs regulation. Who will pay the alimony to whom? So alimony provisions came. So state should step in only when the state feels that it is in legitimate state interest to regulate a relationship, and therefore recognition is only a consequence of that decision. Hypothetically, para 3, it would be possible for a new religion, suppose new religion comes, to provide for a new form of marriage and new ceremonies for the same within the heterosexual fold. Marriage, Special Marriage Act or Hindu Marriage Act doesn't provide for any particular mode of marriage. Except in case of Hindu Marriage Act, it is that Saptapadi, etc. But suppose, someone just garlands each other in a temple. It's a valid marriage. Would a new law providing for a new mechanism be under an obligation, new religion providing for a new mechanism of marriage, be under an obligation that would be having a right that the legislature must accept that kind of a marriage as well? The answer would be no. Thereafter, second, I'll not read except the argument that marriage is a fundamental right was essentially based upon two judgments of your lordships. One was Shafin Jahan and another was Shakti Vahini. In none of the judgments your lordships were even remotely considering right of non-heterosexual couples to marry. In Shafin Jahan, please remember the facts. One lady, Hadia, a Hindu girl, converted into Islam, was seeking to marry a Muslim boy, and the family of the girl were objecting. Non-state actors were objecting. There your lordships, in a habeas corpus jurisdiction said that it's their right to marry because they are heterosexual couple, and your lordship specifically said that Muslim personal law allows the marriage. You have no business. The presumption was that it was a valid marriage recognized by the law, namely the personal law, Muslim personal law. Your lordships, never remotely considered marriage as an abstract proposition to be declared a fundamental right, or marriage amongst non-heterosexual couples as a fundamental right. Your lordship.
Mr. Solicitor, conceptually, there's a little bit of difficulty about this argument. We understand the drift of the submission. Their argument is not that the state is duty-bound to recognize all relationships.
Yes.
You are saying that, look, there's a gamut of relationships in society. The state is not bound to recognize all relationships in society. Their contention is that by not recognizing same-sex relationships for the purpose of marriage, the state is acting in a discriminatory way. So the argument is really of the anti-discrimination principle. Not so much that the state is bound to recognize it or recognize all relationships in society. They say that marriage is a very vital social institution, step one, that same-sex couples are entitled to the same right to dignity as heterosexual couples, and not recognizing that relationship within the fold of regulation would be to deprive them of all the societal benefits which attach to marriage, and therefore it's discriminatory. So that's the line of...
To which, my lord, I don't wish to repeat, but my lord, just to paraphrase once again, my lord, our respectful submission, my lord, is that this is a reasonable classification.
That's fair, and that you have made your point.
I have already made
now,
it.
Shakti Vahini, and this you have dealt with in point 5, right?
Yes.
You want to read that, or you have dealt
Lord,
with
only highlighted part, my lord, your lordships may come to page 3, my lord.
Page 3, all right.
This is quotation from my lord Shafin Jahan.
Okay.
Where your lordships are very careful, my lord. The only highlighted part, underlined part. But the High Court unwarrantedly took exception to the same, forgetting that parental love or concern, my lord, daughter's parents, my lord, whose girl converted into Islam, concern cannot be allowed to fluster the right of choice of an adult in choosing a man to whom she gets married. That was one of the broad conspectus, that law permits a marriage between heterosexual couple. One is man, one is woman. The family has no business to interfere. Then, my lord, in Shakti Vahini was a different case.
As a Khap Panchayat case.
Khap Panchayat, my lord, completely non-state actors, either by making regulations which they were not permitted to make, or by honor killing and other, my lord, extrajudicial unlawful means they were preventing. And, my lord, at page 4, if you're
point number 8 of your submission, where you have summarized what you're now saying.
Yes, my lord.
Therefore, it is submitted.
Yes, my lord. Therefore, it is submitted that said judgments were given in the context wherein state or non-state actors hindered the choice of a woman to marry the man she wished to. It is submitted that therefore there was an invasive positive act by the state or non-state actors in disallowing the exercise of choice in a heterosexual relationship despite marriage between them being recognized by law. It is submitted that said judgments are not, my lord. Then, my lord, kindly see, I'll not read it, my lord, but this Brown versus Board was cited by Mr. Vishwanathan. My lord, just to argue the separate but equal theory. My lord, this was a case similar to, my lord, what the situation was in India prior to independence with regard to some section of the society. They cannot sit in the same compartment. They cannot sit in the same place. There were different, my lord, provisions made, different classifications made for blacks versus white. So it was a racial discrimination. There was no intelligible differentia. And in that context, my lord, the Honorable Court said that it is not, my lord, your lordship's approach, my lord, para 11, I have, my lord, respectfully urged, my lord. Further, it is submitted that there cannot be a fundamental right, either under Article 14 or 15, to seek recognition to all forms of social relationships. It may be noted that the legislature does not seek to give recognition or any special status to all forms of human relationships. It is submitted that this Honorable Court ought to approach the present question not merely in the linear reductionist sense, as sought to be, my lord, made. This is, my lord, this is a classification made on the basis of nature of relationship. There is a reasonable nexus with the object. Object is the family, family as a unit, family having all incidents of the family, and continuation of the human race. So, my lord, I am not, my lord, repeating. I have already made my submissions, my lord. My lord, Citizenship Act and Foreigners Act, my lord, was thereafter not pressed. But, my lord, for completeness, my lord, at page 6, I have, my lord, put my submissions. I don't wish to repeat because they also very fairly did not press much upon it, my lords.
But then you've finally page 8 at the
page 8, my lord, your lordships, my lord, were pleased to require us to provide a comparative chart between, my lord,
that you have now
that, my lord, that is provided for. And my lord, last submission, my lord, please, if your lordships can come to my note 2. Only, my lord, few good, my lord, illuminating judgments of the European courts, which would assist your lordships, my lord, I missed. And I felt, my lord, after arguing on the last occasion, that taking 10-15 minutes of your lordship's time, I must, my lord, advert to those judgments, my lord. My lord, if your lordships have my second note on fundamental rights, my lord. And this is the last submission, my lord. I will not trouble your lordships anything further. But some judgments, my lord, would really assist your lordships.
The European Convention and its gradual development, that part?
Yes. Lord, may I read 142? In Europe, and the European Court of Human Rights has its seat in so-and-so and is tasked with the compliance by the member states of the European Convention on the Protection of Human Rights and Fundamental Freedoms. The European Court, in the manner, provides an additional forum to litigant to enforce the rights under the ECHR against the against the nation state which is a member of the convention. The ECHR was entered into force in 1950 and is the main treaty which sets out the civil and political rights and freedoms of European states agree to ensure for people living within their jurisdiction. Lord, Article 8 is similar to Lord, Article 20, almost, not word by word, but peri materia. Everyone has the right to respect for his private and family life, his home, and his correspondence. There is a specific right to marry. Please see this, my lord. Article 12 on PDF page 77. Man and women of marriageable age have the right to marry and to found a family according to the national laws governing the exercise of this right. Lord, two things. A, even European Convention recognizes a heterosexual marriage and it makes it subject to the national laws of each member state. Yes. Lord, therefore, the ECHR clearly recognizes right to marry under Article 12. Despite the same, European Court of Human Rights has still date refused to locate the claims of same-sex marriage under Article 12. The European Court of Human Rights had consistently denied all claims of same-sex marriages and still does not recognize marriage to be an enforceable right under the Convention. The European Court of Human Rights, after rejecting all claims for about 2 decades, has only recognized limited partnerships to be enforceable, that too in light of larger socio-political consensus in Europe. But this is not majoritarianism. There has to be a consensus on social issues. The said position is clear from a complete reading of the case law emerging from Europe. The European Court of Human Rights, for the first time, examined the issue of whether two persons who are of the same sex could claim to have the right to marry in the case of Chowk and Kopf versus Austria, and found that Article 12, the right to marry, of the convention did not impose an obligation on the respondent state to grant same-sex couples access to marriage. It was held as under, Lord, and I quote, the applicants were born in 62 and 60 respectively. They are a same-sex couple living in Vienna. Lord, kindly skip the, Lord, para 50, kindly come to para 58 directly. The court is not persuaded, Lord, it's on page 78, para 58. The court is not persuaded by the applicant's argument, although, as is noted in the Christian Goodwin cited above, Lord, some other previous judgment, the institution of marriage has undergone major social changes since the adoption of the convention. The court notes that there is no European consensus regarding same-sex marriage. At present, no more than 6 out of 47 convention states allow same-sex marriage. Then, my lord, para 60. Turning to the comparison between Article 12 of the Convention and Article 9 of the Charter, the court has already noted that the latter has deliberately dropped the reference to man and women. So, and so, my lord, I skip the commentary of the Charter, which became legally binding, my lord, that's for them, my lord, to para 62, 61 and 62. Regard being had to Article 9 of the Charter, therefore, the court would no longer consider that the right to marry enshrined in Article 12 must in all circumstances be limited to marriage between two persons of the opposite sex. Consequently, it cannot be said that Article 12 is inapplicable to the applicant's complaint. However, as matters stand, the question whether or not to allow same-sex marriage is left to regulation by the national law of the contracting state. In that connection, the court observes that marriage has deep-rooted social and cultural connotations which may differ largely from one society to another. The court reiterates that it must not rush to substitute its own judgment in place of that of the national authorities who are best placed to assess and respond to the needs of the society. In conclusion, the court finds that Article 12 of the Convention does not impose an obligation on the respondent government to grant a same-sex couple, such as applicants, access to marriage. My lord, similar is the judgment at page 147. I will not read it, my lord, but same court, lord, similar reasoning.
Sir, Solicitor, we've seen it. Yeah.
Your lordships have seen other judgments, but only one thing. Last, my lord, one page, para 148, my lord, that Oliari judgment which was relied upon. My lord, there the court, my lord, this was not read before your lordship, therefore it's my duty. The court records that in this country, there is a larger consensus. Whether your lordships would adopt that, my lord, doctrine or not.
After that, there was a law after that.
Exactly, my lord. Therefore,
there was a law, but they did not say marriage. They said same, I think it's a civil
partnership. They said partnership. So, my lord, I am not reading, my lord, but I have collated all judgments on the point, my lord, and placed for your lordship's consideration. Lord, I'm immensely grateful, my lord. Lord, the learned attorney, my lord, would like to assist your lordship.